and thank you for joining us for today's webinar. Before we get started, I have a few housekeeping notes. For the benefit of all participants, attendee lines have been muted. Should you have any questions that you would like to submit during the event, you may submit them through the question and answer space. If we cannot address your question during today's webinar, we will follow up after the program. Please note that today's webinar will be recorded and circulated to all registrants via email after the event. Should you have follow-up questions at the time, please reach out to any of the key contacts listed in the email communication. Note, Dentons can only issue CLE credit for attendance during the live broadcast of the webinar. Participation on the live webinar must be in a computer or laptop device. Credit is not available for joining via mobile device. One other important note, if you have a New York, New Jersey, Pennsylvania, or Kansas license, please be sure to listen for the code word given during the program. When prompted, you will need to enter the code word into the Q&A section of the screen. If you do not have a license in these states, you can disregard this. I'm Erin Schick. I am a partner in the Cincinnati office. I specialize in employee benefits and compensation, and I am very excited to be joined by my colleague, Kate Ertl, from the office managing partner of our Indianapolis office. Kate?
Thanks, Erin. Sorry, I wasn't quick enough to get to your introduction slide. Hi, everyone. My name is Kate Ertl. I am in our Indianapolis office. I'm a member of our labor and employment group, and I work with employers of all sizes, big and small, on kind of all things touching on employment. Thank you for having me today, Erin. Thank you for the invitation. Today, we're going to start out talking about, we did this in reverse order, didn't we, Erin? Here's Erin's slide. Sorry about that. Erin's slides, you can see her up close. Thank you all for having me. We'll get started now, and I'll get oriented. Just looking at myself and our screen, it's hard to not see everyone. So we're going to talk about HR update and then also benefits update. I'm going to start with our legal update on HR matters this morning. I feel a little bit like a law professor, which I'm really not qualified to be, but all of the topics that were coming to mind, all of the things that have been happening over the last 6 months or so have really been in this area of administrative law that I think I took a class in law school on administrative law. Maybe some of you all did as well. And then we all kind of move on and forget about how this concept of administrative law and how it interacts with the courts, it interacts with our federal and state governments. We forget about how that impacts really our daily lives. And recently we've been feeling how that impacts our work. So I'm going to talk about a few things that have happened over the last few months, most of which you have probably heard something about or been following, at least moderately on your radar to kind of see what was going to happen. And I'm going to try, hopefully I'll succeed, but I'm going to try to tie all these things together for you so that we can see really how these things are all related and maybe give us a little bit of thoughts about what might happen in the future, what we might be looking for. I always joke that I did not receive my promised, 2020 hindsight vision or my crystal ball in law school. So no predictions really for me as to what might happen. But I do think that the last 6 months give us a little bit of insight into what we might be expecting with respect to how the administrative world is impacting employers. All right, so where I'm going to start is March 2024, when we've been receiving some interesting information from the National Labor Relations Board with respect to bargaining and with respect to what employers are permitted to require of employees with respect to confidentiality. So we've seen a pretty active board over the last several years, making some interesting rulings and issuing things that have changed the way that we do business in terms of HR. So one of the things, for example, you might have seen is your lawyers recommending minor changes, but changes nonetheless to your settlement agreements, your separation agreements, and your employment agreements with respect to non-disclosure, confidentiality, and disparagement. So we've been adding some pretty standard language to those agreements that says something like nothing in this agreement does or is intended to violate the employee's rights under the National Labor Relations Act. And that flowed out of a decision by the National Labor Relations Board. So the issue that we're really talking about here today, though, is with respect to this March 2024 ruling. So the history is this. Under the law, employers are prohibited and governed in terms of what they can do and not do with respect to organizing, labor unions, collective bargaining, and employees' rights in the workplace to organize and to raise complaints. Under the NLRA, joint employers, so employers who employ more than one set of workers, or workers who work for maybe one or more employers. So, for example, in the context of temporary agencies, this joint employer rule kicks in under certain circumstances and may qualify under the NLRA as an employer for purposes of the NLRA. So being a joint employer is something that many employers are interested in knowing whether or not they need to comply. You need to know, am I a joint employer with respect to the group of workers who works in my facility or works on site with us, but is not actually directly employed by my entity? So knowing whether or not you're a joint employer is really important with respect to the National Labor Relations Act if you're in any kind of industry that might be subject to bargaining. In 2020, the NLRB adopted a rule that we call the 2020 rule that established that an employer would only be considered a joint employer when it exercises substantial, direct, and immediate control. So this was a good ruling, a positive ruling for employers, because it basically said if you have someone working on site, maybe you hire a grass cutting crew to work on site and come on every few weeks to cut the grass or once a week to maintain your outside facilities. You are unlikely as an employer to be a joint employer of those employees because it's unlikely that you really have any substantial, direct, and immediate control with those individuals. They likely come on, they bring their truck, they drive their lawnmower off, they cut the grass, and they leave. You later get an invoice, and that's really the only interaction that you have. So unlikely under those types of circumstances to have NLRB influence over those particular employees with respect to your business. The new rule in 2023 significantly expanded this analysis and basically said if you have any control whatsoever, if you have any control, even just a reserved control, something like with respect to these grass cutting workers, we'll say grass cutters come on, we have a provision in our contract with the primary employer, with the entity that is employing the workers who are coming to cut the grass that says something like if they are found smoking on our premises, we reserve the right to terminate the contract. That kind of reservation of rights that could impact those individuals' employment would, under the 2023 rule, trigger a broader coverage of joint employer liability or joint employer status with respect to your entity and those additional laborers who are coming on site. So significantly expanded the opportunity or the risk for an employer and to be subject to potential bargaining from individuals who come on site, even if they're not directly employed. This was really critical in a lot of industries and kind of raised the hair on the back of the necks of many, many employers in certain industries who are looking at the potential to have working groups or subsets of working groups suddenly become part of their workplace for purposes of bargaining. So created some fear, some anxiety, created some changes for some workers or workforces with respect to how they do things, because we all want to have a little bit of control over whether and when our business might be subject to bargaining. Good news. On March 8th, 2024, the U.S. District Court for the Eastern District of Texas struck down this 2023 rule and basically said too broad, overreaching, really potentially has a negative icing, chilling effect on the ability of businesses to work together and for certain work to be done. So good news for employers. We're back to the 2020 rule, which is a much more modest, I guess, way to capture what it means to be a joint employer. So note a couple of things here. So this is starting back in March of 2024, striking down a 2023 rule, and also looking at where we are in terms of which court. So Eastern District of Texas. Texas is a common theme of my part of the presentation today. So keep your eye on that. We have a question. I'm going to try to answer these as I go. Was the decision striking down the 2023 rule appealed? I honestly have no idea. I apologize. I do not know whether or not it has. I wouldn't be surprised if it was. Um, Although, given the things that have happened subsequently from this decision, that might give us a little bit of a clue as to what we could expect, at least in the short term. So, if anyone knows that answer, feel free to share it, and I will share it with everyone. I don't know right off the top of my head, though, and Jody, happy to provide that information after today's webinar. Good question. So moving on, so that happens in March, kind of feels like a win for employers. We breathed a little bit of a sigh of relief with respect to most of our clients who are looking at trying to avoid organizing campaigns within their workforces. We move into April, and in April, we start focusing on and anticipating and expecting a few decisions to come down on certain things that employers have been talking about for several years. So the first thing that happened is that the FTC non-compete ban, a rule that we had been anticipating for many months, finally makes its appearance, comes on the scene. We know what this rule is now going to say. So in 2024, April 2024, the Federal Trade Commission issued its new rule that effectively banned almost all non-competes. So if you were paying attention, if your business has non-competes, if you're subject to a non-compete yourself, you might have been looking at this with kind of anticipation of what's going to happen to this rule in terms of what we're going to be able to do with our non-competes. So under this rule, as we know, I have to back up, just setting the scene again. I can't see anyone, so I don't know who I'm looking at in terms of my audience. But non-competes are contractual provisions that many employers use to restrict an employee's ability to engage in certain conduct, competitive conduct during and after employment. These are often challenged. They are often the subject of cease and desist letters, challenges in court. We talk about whether or not these agreements are reasonable, whether or not they satisfy the state's requirements with respect to geographic scope, time limitations, services provided, and things of that nature. Because they're contractual provisions, non-competes typically fall under state law. So we also know that a number of states, California, for example, outright ban non-competes. So non-compete provisions with respect to employment in California are almost entirely unenforceable and void. This non-compete rule, which was first proposed back in April, back in maybe April of 2023, the rule was initially presented, went through the notice and comments period from the Federal Trade Commission, and then about a year later, the FTC issued this rule that came out and said that almost all employment-related non-competes would be banned. There were a few exceptions, and those included certain employees who had existing non-competes and who made a certain threshold of money and worked in certain types of jobs. But those were very limited and limited to really kind of just the highest level of executives. And only the non-competes that were currently in place as of the effective date of the rule could remain. New agreements in the employment context would not be valid. The effective date of this rule was planned to be September 4th, 2024. So as we rolled out of April, pretty quickly, almost immediately, there were 2 lawsuits filed, both in Texas, federal district courts in Texas, challenging the rule on the basis that the FTC had exceeded its authority with respect to rulemaking. So all summer, some of us, me anyways, were waiting for some sort of decision so that we would know what we needed to tell our clients with respect to any non-competes that they had already on the books. Because one of the features of this rule was that employers would be required to notify employees that those certain provisions of existing non-competes were no longer valid and enforceable. So we had started drafting notices. We had started drafting what this language might look like in terms of how we were going to notify employees that provisions of their non-competes were no longer valid. We were also looking at how we would revise the employment agreements and other agreements that our clients had with their employees to make sure that they would be enforceable with respect to non-solicitation and confidential information, because those provisions were not, on their face anyways, affected by this non-compete ban. Okay, so that was April 2024. Another item that came out in April 2024, keeping us busy trying to think about what we needed to advise our clients with respect to their workforce, was a new rule issued by the Department of Labor under the Fair Labor Standards Act. So under the Fair Labor Standards Act, employees are entitled to overtime at a rate of 1.5 times the regular rate of pay for every hour worked over 40 in a given work week. States may have their own separate laws or their own additional laws in addition to this FLSA rule, but all employers are subjected to this FLSA rule. There are some limited exceptions or exemptions from this FLSA overtime rule. So employees who are paid on a salary basis and who make at least a certain amount of money per week and perform certain types of jobs can be exempt from overtime requirements. So it is really critical for most employers to understand the thresholds of this rule so that employees can be paid properly. It is a violation of the FLSA to not pay overtime to an employee who is entitled to it. And that can trigger class action lawsuits, significant penalties, attorney's fees, and things of that nature. So most employers are working pretty hard to make sure that they understand the FLSA and have properly classified their employees. So on April 23rd, 2024, the Department of Labor announced a final rule that updated the FLSA regulations regarding overtime. The primary change that it made was increasing that threshold with respect to the amount of salary that these employees need to make in order to be exempt from the overtime rule. So as of July 1st, 2024, the minimum salary rate needed to be increased from $684 a week to $844 a week. So a fairly significant increase. So in order for an employee on the last day of June to be eligible to be considered exempt and not entitled to overtime, they only needed to make $684 per week. The following week, the first week of July, they needed to make $844 a week in order to maintain the exemption. If an employer did not increase or has not yet increased the salary of any of those employees who they currently treat as exempt to meet this new salary threshold, those employees are now misclassified and they are entitled to overtime. The second part of the rule, so that has taken effect. That rule is in place. So if you are thinking about, oh man, I don't know where I was this summer, I don't remember hearing that. My counsel didn't notify me of that. I didn't read the information. You might want to double check with your team to make sure that employees have been evaluated to determine whether or not their salary needed to be increased in order to maintain the overtime exemption. And then either that needs to be increased if the exemption, if you want to still use the exemption, or the employee needs to be reclassified and treated as an hourly employee who's eligible for overtime. The second part of the rule is even more significant. I didn't really hear or see a whole lot of employers making much of a stink about the July 1st deadline. I didn't have many calls asking about that. It seemed as though most people felt like their workforce was already meeting that with respect to the exemption. But the rule is changing again, or the threshold is changing again as of January 1st, 2025. This same rule had a kind of a two-tier approach, really a three-tier approach, but the first two tiers were July 1st and then January 1st. So as of January 1st, that rate needs to increase again, this time to $1,128 per week. So this is pretty significant. If you think of just when we get to January 1st, in order to be exempt, an employee is going to need to make $1,128 per week. That's what, almost double? I'm not a mathematician, but almost double what it was as of June. So just 6 months prior. So pretty significant increase. So I have had many clients calling with concern about that and how are they going to manage reclassification if necessary? How are they going to move their employees to keeping track of their time when they have a significant amount of their workforce that has always been considered and treated as exempt? Folks who are not used to keeping time sometimes don't want to start keeping their time. So a lot of employers are starting to think about how are we going to adjust in order to either increase compensation as necessary or reclassify our employees as hourly and treat them as such. No, not a surprise that challenges to the rule have been filed in federal court in Texas. Not a surprise, but in Texas. To date, no nationwide ruling has been issued. So as of right now, the July 1st threshold change is in effect and has taken effect. The January 1st threshold change is still on the books. And at this moment, you should anticipate that that will take effect, and employers should start looking at what changes might need to be made to address those threshold changes. The District Court for the Eastern District of Texas enjoined the rule, but only as it applies to the state of Texas. So if you're doing a Google search and you find something that says that the rule has been struck down, at least as of today, that ruling is likely the one that only addresses the state of Texas. We, of course, expect there to be an additional ruling, hopefully sooner than later, so that employers can act in a timely fashion if they do, in fact, need to make this change. Okay, so then we move into this summer, and we have this is where I really feel like an unqualified law professor talking about the Chevron case. So if any of you have been reading law blogs or reading news articles or reading any of the information that Denton sends out, we've had a number of publications on Chevron and the overturning of the Chevron rule. This is impacting not just the labor and employment area, but really all areas that administrative law impacts. So environment, healthcare, you name it. There is potentially some impact that this new decision is having. So let's talk about what that is. And this is, again, I feel like Law School 101, Administrative Law 101. The Administrative Procedures Act is a federal statute that established a private right of action to challenge actions taken by federal agencies. So under this law, courts have the authority to review and invalidate agency action that is arbitrary or capricious or in excess of statutory jurisdiction, authority, or limitations. Agency action, if you're thinking to yourself, well, what exactly is agency action? Well, that's all of the things that we've talked about up till now in this presentation. So the NLRB's rules, the FLSA change from the Department of Labor, and the FTC's rulemaking. Those are administrative actions. Those are the agencies attempting to implement the statutes that fall under their purview. Courts have typically given deference to federal agencies in their rulemaking, the idea being that legislators cannot write a statute that covers every event that might occur. And they also can't write statutes, or renew statutes every year or every couple of years in a way that addresses the changes that we see in society. So agencies that are authorized to administer those statutes have some authority to make rules and to make regulations that help to implement the statutory guidelines. In 1984, so 40 years ago, the U.S. Supreme Court in the Chevron case established a two-part framework for how these challenges under the APA would be decided. So in the event that someone were to raise a claim or raise a challenge to an administrative action under the APA, this Chevron case for 40 years has dictated how courts would analyze and evaluate whether or not those administrative actions were legitimate. And the Chevron test is known as being deferential, gave kind of additional and extra authority to the administrative agencies. Okay, and with that, we're going to take a quick break, the easiest part of my presentation. I'm going to give you our CLE code word. As mentioned at the beginning of the webinar, we need to take a moment to satisfy CLE requirements by delivering the following code word. Kansas, New York, New Jersey, and Pennsylvania licensed attendees must type the code word court into the Q&A section of your screen. Please make sure to hit send so that it registers. In case you missed it, the code word is court, and you should see that on your screen. I'll give everyone a couple seconds to comply with that, with the code word. So moving on, so Chevron, the Chevron doctrine, what was it? It is important to understand that, even though I'm getting ready to tell you that it's been overturned and maybe you think you don't have to worry about it anymore, it is important to understand what the Chevron doctrine really has done with respect to administrative agencies and rulemaking over the last 40 years. So at the first step of the Chevron analysis, the court determines whether Congress has directly spoken to the precise question at issue. If the answer is yes, then the matter is resolved. If the legislature has unambiguously legislated. They have unambiguously expressed the intent of Congress with respect to a statute, with respect to what the rules should be and how it should be administered, then the administrative agency doesn't have any say. The administrative agency basically has no business regulating or rulemaking when Congress has spoken. The rules of Congress, the direction of Congress, as expressly identified in the statute, will prevail. If the answer is no, though, and there's any ambiguity or there's any question as to what the statute says about how that law should be implemented or interpreted, then the court moves on to step 2. Under step 2, the court will look to see whether or not the agency's answer is based on a permissible construction of the statute. And the court looks to see whether or not the agency has adopted a reasonable interpretation. So when the Congress is silent with respect to any issue, it leaves the door open for an administrative agency to come up with some reasonable way to administer and exercise its authority under the rule. The Chevron doctrine rests on an assumption, really the Supreme Court's assumption 40 years ago, that Congress, when they left ambiguity, actually intentionally intended for the agency charged with implementation to have discretion. So 40 years ago in the Chevron case, the court ruled that if Congress has not spoken, they must have meant for someone else to speak. And we're going to give deference, we're going to give authority, and we're going to give a little bit of freedom to agencies to determine what those rules should be and to fill in the blanks as needed. So under Chevron, which we have lived under for 40 years, we have regularly seen administrative agencies make rules and go through the process of rulemaking, the notes and comments process, and determine how they think a rule should be, how a statute should be implemented. So, for example, with respect to the thresholds for exemption from the FLSA, those thresholds themselves are not in the Fair Labor Standards Act. But the Department of Labor has long held the position that it has authority to regulate and determine how those types of exemptions will be applied and what the thresholds will be. Enter the Loper Bright case in June. It's been pending for some time, and many smarter people than me were probably kind of on pins and needles with excitement, waiting to see what the court was going to decide in this case. There was also a sister case as well, both consolidated for purposes of this ruling. In this case, on June 28th, 2024, the Supreme Court overturned the Chevron case and basically ended this 40-year practice of deference to an agency's interpretation of an ambiguous federal statute. The court has, in some articles that I've read, taken back the reins, taken back authority, and focused on its traditional role of saying what the law is. Courts have basically said that, hey, we as the court, not the administrative agency, we are the interpreters of the law. We are the ones who get to say what a law means and how it should be applied. When there are blanks, we should not just automatically defer to an agency to fill those in. There needs to be some court intervention. And so basically saying that any deference that's given to any branch of government is not absolute with respect to the interpretation of a law. So not only can an administrative agency have sole authority to determine what the law means, but neither can the executive branch either. So that was an interesting outcome. Whether it was anticipated or not, I really don't know. But I know that as soon as this came out, we were seeing numerous articles, numerous letters. I'm sure that there are law students everywhere claiming this for their law review note or comment this year, because it really affects, like I said before, so many areas of our everyday life with respect to these administrative rules that we just kind of naturally comply with, and that impact our work and impact our days. So very interesting decision. One of the other components of the Chevron overturning was the court's decision that it was at odds with the APA itself. Again, because under the APA, the courts, not the legislature, are tasked with determining the meaning of statutory provisions. So again, this is a signal to me of the courts reclaiming some authority, reclaiming their power, if you will, to interpret the law. Finally, the courts rejected the Chevron concept that ambiguity is signaled and expressed an implicit delegation to the agency by the legislature, basically saying that just because the legislature didn't think of it or just because the legislature didn't get specific enough doesn't mean that they intended for an administrative agency to fill in the blanks. They also said, I think it's worth noting, agencies have no special competence in resolving statutory ambiguities. Courts do. So again, we're seeing the federal court, the highest federal court in the United States, making a pretty strong assertion that, hey, we're in charge of interpreting the law. And I think it'll be interesting to see. It's already been interesting to see, and it will continue to be interesting to see what exactly that means going forward. I'm hoping no one has any questions because I don't know that I'll have any real good answers, but yeah, give that. Look, there we go. So the Chevron case being overturned, what does this actually mean for employers? There are plenty of resources online that you can find about what this means for employers and for businesses and for individuals in all different contexts. In the employment context, though, it's important to know that previous decisions that relied on Chevron currently remain untouched. So the court did not go back and issue any sort of announcement that invalidated any prior court decisions that had validated agency decisions on the basis of a Chevron analysis. But going forward, courts must exercise independent judgment in reviewing agency regulations. So there's no more two-part test. Courts will continue to consider whether an agency's interpretation is valid, and they will just look to see whether it's persuasive and reasonable. But there will not be this automatic two-part test that provides the same level of deference that we saw under Chevron. So some of the agencies that regulate in the labor and employment space, such as the EEOC, the Department of Labor, OSHA, the Federal Trade Commission, the National Labor Relations Board, they have regularly relied upon and invoked Chevron in their rulemaking. So, for example, the FTC issues its non-compete ban. They relied upon their understanding of Chevron and the authority that they have under Chevron and the APA to rulemaking with respect to joint employer rules. So going forward, when these agency rules are challenged, this post-Chevron outcome could be different. We might be seeing different outcomes than we would have seen 6 months ago. If you recall back to one of my first slides, or maybe it was my first substantive slide, saying the writing was on the wall. And that's with respect to the idea that initial decision back in March, when the courts struck down the NLRB's joint employer rule, was a little bit of a signal of maybe Chevron is not long for this world, and we're going to stop giving quite as much deference to these agencies in their rulemaking. So some of the other rules that have been challenged in their current status include that FTC non-compete rule that we talked about. That rule has been set aside on the basis that it overstepped the bounds of, and we'll talk about this a little more in the next couple of slides, but overstepped its bounds, that the agency had over-rule-made and had overstepped its bounds with respect to that rule. Also, the EEOC's final rule on the Pregnant Workers Fairness Act has been challenged by employers, and that has currently been enjoined by a federal court. The Department of Labor's tip credit final rule was challenged on the basis that it violated the FLSA and exceeded rulemaking authority, and that rule has been vacated. The one rule that we're still waiting on is the one that I mentioned previously on the Department of Labor's overtime rule. So the second wave of changes set to take effect in January is still currently on the books, but also still currently being evaluated and may very well be decided under kind of a new regime, a new set of evaluation under the Loper test, as opposed to Chevron. Okay, so we'll dive a little bit more into each of one of those things. So as of August 20th, 2024, which was just 2 weeks before the ban's effective date and a few weeks after the Chevron case was struck down in the Loper case, a federal judge in Texas ruled that the FTC's new rule constituted unlawful agency action under the APA because the FTC exceeded the statutory authority granted to it. They also called the rule arbitrary and capricious. So as a result, the rule has been set aside and is currently enjoined and taking effect on a nationwide basis. So your non-competes as written remain in effect under federal law. And you can continue as an employer to draft these agreements, to have these agreements with your employees. Remember, though, obviously, not a free-for-all. There are still state statutes that in many cases govern and control whether non-competes are valid, and then also state common law that governs how broad a non-compete can be in order to be enforceable. As noted, so we don't yet know what's going to happen with the FLSA new overtime rule, but Texas courts do continue to consider the merits of the cases before them, and they very well make their decision on the basis of LOPR. At least one of the judges who's already considering those cases has issued, I don't know if it was an order or just a notice, but indicating that they were aware of the LOPR decision. So these federal judges are highly aware, very acutely aware of the LOPR decision in Chevron, and as well as the litigants. They are going to be, people challenging the rules are absolutely going to be citing to LOPR and the overturning of Chevron with respect to their arguments going forward. Okay, top 5 for 2025. So everyone wants to know, okay, well, that was a whirlwind. A lot of hubbub about nothing. With respect to the non-compete rules, we still don't know what's going to happen with our overtime obligations and how much we might need to pay people in order to avoid the overtime regulations for exempt workers. So what's going to happen next? I don't know. Didn't get my crystal ball, but some of the things that I'm keeping an eye out for are, I mean, very obviously, we're probably all anticipating and know for a fact that the outcome of the presidential election will absolutely impact the policies and rules with respect to labor, employment generally, but also labor specifically. So under the Republican agenda, it's called Project 2025. The Democratic agenda is full of a number of wage and labor protections. I think we're all still waiting to really hear what exactly the current candidates are proposing in these respects, but we can expect if we see a Republican president, we will see Project 2025, which would reduce the authority of labor unions, reduce the power of the NLRB with respect to organizing. And then on the alternative side, with respect to a Democratic agenda, we would see wage and labor protection. So increase in wages, increase in minimum wage possibility, things like that will continue on that same path, which we have seen from time to time with Democratic presidents in place. Number 2, the impact of the salary threshold. So we don't know whether or not this FLSA rule is going to take effect with respect to the next wave of increases. But again, one wave has already occurred. So whether or not employers were paying attention, whether or not employers made the necessary changes back in July to increase the salary thresholds with respect to exempt workers, will likely have some sort of trickle-down effect. So I'll be interested to see whether over the next 6 months to 12 months, we see an increase or any kind of jump in the number of FLSA lawsuits alleging misclassification of workers. The next one is state paid and sick leave and paid family leave rules. Over the last 10 years or so, every year we've seen a number of states adopt new rules and new laws and regulations with respect to how employers are required to treat employees with respect to paid sick leave and paid family leave. Still remains kind of a question as to whether or not we might see a change at the federal level. But for now, we should definitely continue to keep an eye on state-based rules and the changes that happen state by state. This is also really important for employers and something that many of my clients have faced with respect to the growth in remote work. So, more and more employees are moving to new states, live in new jurisdictions because they don't have to work jurisdiction as their employer. One of the things that can happen with that is that an employee moves, maybe doesn't notify the employer of their relocation. And once that employee moves as a resident of a new jurisdiction, they most likely need to be treated, paid, compensated, provided benefits consistent with that particular state. So it's important for employers to know where their employees are residing, know where your employees live and what state they're claiming, both for kind of administrative purposes of making sure that you're properly registered, workers' compensation is taken care of, unemployment compensation is taken care of, but then also with respect to benefits related to paid sick leave and paid family leave. State non-compete bans. So now that we have the ruling striking down the FTC's rule on non-compete bans, I think we should continue to keep an eye on state legislation, state rules that would ban non-competes. Again, there are a number of states that already have rules on the books with respect to non-competes. They vary widely in what they require. And so again, it's worth noting and understanding where your employees live so that you know whether or not your non-competes are going to be valid. One thing that's notable is that for most states, in the context of a non-compete agreement, a choice of law provision will not save a non-compete agreement. So just by way of example, to pick on California, an employee who lives in California might sign a non-compete agreement that says that Indiana law applies. California will not enforce that non-compete agreement, and it is essentially not valid because the employee is in California. So again, this is one to be really mindful of and make sure that your drafting is precise and considers where the employee lives, and this issue that just designating the state law that you want to apply is likely not going to be good enough. The next one is AI in hiring. This is something that we've been seeing happen a little more frequently. You know, many employers use some form of AI in their recruiting, in their soliciting, and in their filtering of candidates for jobs. There have been a lot of discussions about whether that might violate discrimination laws. So keep your eye on that. Be aware of what your HR teams are doing and what your recruiters are doing with respect to identifying candidates, making selections for who will be interviewed in person and things like that to avoid running afoul. All right, well, I have sped through my time, which I don't normally do. Happy to take any questions that you might have before I turn it over to Erin. Give everybody a couple seconds. All right, I'll give you all your honorary degree in administrative law today. Thank you so much. Let me know if you have any questions. I'll be here the whole time. So if you think of any as you're moving through, I'll try to respond to those in the chat. All right, Erin, you're up. Thank you.
Thanks, Kate. Hi, everyone. I'm going to be providing an employee benefits legal update. Obviously there are some hot topics, and you'll have to forgive me. I am going to use my notes, and I'm going to try to give you the latest and the greatest because since I finalized these slides on Friday, there have been 3 developments impacting things I'm going to talk about, one of which is significant. So I'm going to try to give you the latest and greatest. But I wanted this to be a holistic overview of things that I'm talking about with my clients, things that plan sponsors should be thinking about. So for qualified plans, we're continuing to implement and roll out Secure 2.0. Where have we gotten in terms of additional guidance? The big thing in qualified plans right now is forfeitures, the litigation surrounding that. So we'll definitely hit on that. Welfare plans, we have the HIPAA final rule regarding reproductive health information, fiduciary best practices. Again, that relates to a recent litigation trend in regards to welfare plans, fiduciary obligations. And then the mental health parity and addiction equity rules, which were in a proposed state until Monday, in which they were finalized. So that's a pretty significant development that I'll walk through. Then cybersecurity and AI, I think this is something that all plan sponsors hopefully are continuing to think about and have these conversations, but it's important. And then a litigation update. We're seeing a lot of new and interesting litigation trends. ESG and mortality tables, those are older trends, but they're not going away. Section 1557 and family planning benefits, those are kind of new litigation trends. fiduciary liability. And then fortunately, Kate set up a really good explanation of Chevron. So I'm just going to glaze over it. But now that you have an understanding of Chevron and agency deference, talking about the impact that that might have on some of the current litigation. So, in terms of qualified plans, obviously the most significant piece of legislation surrounding qualified plans was Secure 1.0, which came out in 2029, and then Secure 2.0 that came out the end of 2022. It was part of the Consolidated Appropriations Act for 2023. Secure 2.0, I would say overall has the aim of encouraging and bolstering retirement savings accounts. So there were some required provisions of Secure 2.0 and some permissible provisions. And what's interesting, and I have some of my clients say, well, I haven't, even the required changes, I haven't amended my plan. There's always this dichotomy between when amendments are due, but the effective date of compliance. So, for example, the RMDs, which we're going to talk about, the age 73 change, that already went into effect. Your plan needed to be in compliance as of the first of this year. However, the amendment deadline for all of the secure amendments, even if it's a discretionary or required change, isn't until December 31st of 2026. So you need to be in compliance with the required provisions, but you might not have updated your actual plan document. But there are optional provisions. And for a lot of the optional provisions, I expected clients to have maybe more uptake initially, but I think a lot of us were waiting for additional guidance. And one of the pieces of additional guidance that I was getting a lot of questions about was qualified student loan repayments. So this has been something that employers have been asking about for a while. We had the Abbott Labs private ruling, and essentially the idea being employers are saying that we have millennials and Gen Z who are not participating in our qualified retirement plan because they have such high student loan payments that they can't afford to contribute, and they're missing out on matching contributions. So can we treat their student loan payments as elective deferrals into the plan for purposes of giving them matching contributions? So we had the Abbott Labs private letter ruling, and then Secure 2.0 actually codified this idea and said, yes, you can. You could effective beginning January 1st of 2024. But again, I think there were a lot of questions in terms of non-discrimination testing. How do we actually implement this? So the IRS did give us guidance. It's IRS Notice 2024-63, and it addresses issues like eligibility, certification, testing, and procedures to administer a plan with this qualified student loan repayment matching feature. So if this is something you've talked with your advisors about, or you want to talk to your advisors about, now that we have more guidance, I expect some plans might start implementation. Similarly, Secure 2.0 had a variety of permissible in-plan withdrawals. Again, the idea being we want to not dissuade people from saving into their 401k and making it seem like the monies are permanently locked in. So Secure 2.0 came out with a variety of permissible withdrawals that plan sponsors could choose to implement, one of which being domestic violence withdrawals. I guess statistically, 1 in 4 women and 1 in 7 men will experience domestic violence in their lifetime. And there's obviously costs associated with potentially leaving a violent partner. So I guess that was the impetus for Congress to allow this type of withdrawal. In June, we received IRS Notice 2024-55, which provides guidance on that type of early withdrawal. So if, again, that's something you want to consider implementing in your plan, now we have additional guidance. Final RMD regulations. So there was some confusion here. Secure 1.0 changed the 5-year RMD distribution rule to a 10-year RMD distribution rule. And there was some confusion because under the 5-year rule, and the least is rapidly requirement, you could wait the entire 5 years and then pay out as a lump sum. Secure 2.0 changed that. And what happened was the IRS, they kept saying, okay, well, under the 10-year rule, we assumed it was previously that we could pay out as a lump sum at the end of 10 years. The IRS came out and said, no, you're actually required for a participant who dies after their RMD date, you're required to make annual distributions over the course of those 10 years. So that was kind of a surprise. And as a result, we had transition relief up until the most recent was 2024 54, but that's going to end January 1st of 2025. So the reason I bring this up, even though it's Secure 1.0, is that if you've been not complying with the RMD requirements regarding the 10-year distribution rule, the relief has expired. So as a plan sponsor, I'm sure the record keepers are on top of this, but that is going to be the transition relief is expiring. So that brings us to forfeitures. And what is kind of ironic about forfeitures is that this has been something that I don't think has been really thought about or discussed since 2022. And then in 2023, the IRS proposed regs. And then shortly thereafter, in 2024, there became kind of a litigation trend surrounding forfeiture. So it's just interesting that this idea is laid dormant and no one's really had discussions about forfeitures in quite a while. And now we're having these discussions. So again, like I was saying, previously guidance from the IRS and DOL regarding when defined contribution plans need to use forfeitures was very murky. There was a spring 2010 newsletter that said you just can't keep them in a suspense account for several years. So this idea that you needed to use forfeitures eventually, but there wasn't a strict timeline. And let me back up even a little bit further for those of you who might not regularly work in this space. Forfeitures are amounts that exist in a plan because an employer makes matching or non-elective contributions that are subject to a vesting schedule. And then the person terminates employment and hasn't fully satisfied that vesting schedule. So they forfeit the unvested amounts. So that is what constitutes forfeitures in a plan. So back in 2023, the IRS proposed some regulations giving some clarity in terms of when plans need to use forfeitures. I think they expected that those proposed regs would have been finalized already because it gave an effective date of 1/1/2024, as you can see on the slide. I don't think this is something that is going to be retroactively effective. So I'm assuming the final regs will have an effective date of 1/1/2025 or even later, depending on when they get to it. But essentially, the proposed rule says a 401k plan must use forfeitures no later than the 12 months following the end of the plan year in which the forfeiture occurred. It also built in a grace period for employers who might have a significant forfeiture account they've just kind of been letting sit there and haven't been spending. So again, this was using 2024 and 2025. I expect the dates to be adjusted, but it gives a grace period of an additional year for forfeitures that occurred in prior plan years. So again, we're waiting for the final regs on this, but that's kind of the gist of the guidelines. And for plan sponsors, wait until the final rules are issued. But in terms of forfeitures, because we're going to start looking at this in terms of the fiduciary breach litigation, which I'm going to talk about. But when you're looking at your plan document, if you have a provision that all of the forfeitures have to be used within the plan year in which they are forfeited, that's pretty limiting and that puts you on a pretty tight timeline. So you might want to consider amending it so that you can get the larger period now permitted by the IRS. Similarly, if you have a significant forfeiture account dating back a number of years, when the final rules are implemented, you're probably going to want to put some language about the grace period in your plan amendment, allowing you to take advantage of it. So the proposed regs let us know when we are supposed to send the forfeitures. The question becomes, how do we use forfeitures? And previously, I would have told you that The IRS does permit plan sponsors to use forfeitures for a variety of reasons. Um, you can use them to offset employer contributions, administrative expenses. However, you are limited to what it says in your plan document. So if your plan document is hardwired one way or the other, we're going to use forfeitures to offset future employer contributions or offset administrative expenses. You need to follow the plan document. Most plans give the employer discretion, the employer or plan sponsor, and that's an important distinction, discretion as to how to use forfeitures. So they'll say either or, which is what results in this litigation that has started. And essentially, the litigation here is these employers' use of forfeiture monies constitutes a fiduciary breach. So in Perez, both Perez and Rodriguez survived in their motion to dismiss. In Perez, the participants are alleging the employer violated ERISA by using plan forfeitures to reduce its obligations to make matching contributions, rather than using the forfeitures to offset administrative expenses. And because they made that decision, administrative expenses were then passed on to the participant, which is permissible, but that resulted in each participant being charged about $44 a year in administrative expenses that they would not otherwise have been charged if the employer had used the forfeitures to offset the administrative expenses. The plan language, like I said, provided that standard discretion that I see in most plan documents, saying forfeiture shall be used at the discretion of the company to reduce employer contributions, next payable under the plan, or applied to plan administrative expenses. So the plaintiffs in these cases are arguing that there's an employer breach of fiduciary duty because they had the choice to offset their expenses or pay administrative expenses, and them choosing to offset their expenses was not in the best interest of the plan participants. What's interesting is that, again, like I said, the IRS has accepted the practice for decades of forfeitures being used to offset employer contributions. But the plaintiffs in this case are really focusing on that discretion of a fiduciary. And as a fiduciary, they're arguing you need to put the plan participants first, which is true. So that's what's kind of the impetus for this litigation. So in terms of the litigation, again, like I said, we're already going to be looking at how we're treating forfeitures in our plan document. You really have two choices here, how I see it. Well, three choices. You can wait till the outcome of this litigation, see how it turns out. I would imagine, though, it's going to be a mixed bag, like the mortality table litigation. We're going to see some favorable to employers, potentially some favorable to plaintiffs. I would anticipate some settlements. I don't think this is going to be a resolved issue. So for now, what you can do is if, as an employer, you always use forfeitures in a certain way, let's say you always use it to reduce employer contributions or administrative expenses, that's been your past practice, you could consider hardwiring that into your plan document so that there is no discretion or decision to be made. We use it to offset employer contributions. That's our plan design decision done. Alternatively, you can amend your plan to make it the decision of the employer in a set and forget function as opposed to a fiduciary decision. So how you would do that is you would have make the discretion decision to the company, and the company would either, the board would either issue a directive to the plan administrator, or an officer would issue a directive to the plan administrator and say, this is how you are to spend forfeitures this year. Again, that takes the decision away from the fiduciary, the plan sponsor, and puts it back to the company in the set work function. So those are two ways I think that you can address this litigation. Again, I don't think it's going away anytime soon. There's been additional suits brought against Wells Fargo, Honeywell, Nordstrom, Bank of America, Intuit, Clorox, Thermo Fisher. HP thus far has succeeded in its motion to dismiss. And what is also, I guess, concerning from an employer perspective is the trend before we were talking about forfeitures and still ongoing is the 401 excessive fee litigation, where they're saying that 401k plan sponsors violated their fiduciary obligations by selecting record keepers that we're charging excessive fees. Well, now, in light of these forfeiture arguments, they are seeking relief from the court to amend their complaints to add in fiduciary breaches for treatment of forfeitures. So this is something that I think is going to obviously continue to develop, but something as a plan sponsor, you want to be proactive about now. You want to look at your plan document and say, how and when are forfeitures used? And like I said, look at that now in terms of the discretion for the fiduciary litigation, but also consider potential amendments when those final regs are finalized in terms of the timing of using forfeitures. All right, HIPAA and reproductive health. So this is an area where there has been an update since I finalized the sides. I'm going to talk about this because there has not been a decision issued, but Texas recently sued HHS to stop enforcement of this HIPAA reproductive health rule. They are arguing that they need to access this information in order to comply with state laws. So it'll be interesting to see where that litigation goes. So I want to put a big asterisk here. But essentially, this final rule was in response to the Dobbs decision, which obviously took Roe v. Wade and put that back to the states. And they issued a final rule modifying the HIPAA privacy rule back in April of this year. It's called the HIPAA Reproductive Health Rule, the RHI rule. And again, they were concerned that states or other law enforcement agencies would be going to plan sponsors, healthcare providers, and asking for information about reproductive health, and that plan sponsors would potentially provide them that information, thinking it was a permissible disclosure to law enforcement or another agency. So HHS wanted to make it abundantly clear that you are prohibited from disclosing RHI in certain contexts. And it's also important to note that RHI is defined very broadly and includes over-the-counter medications. So it's not just abortion. It includes a variety of things when you're looking at what is RHI. So essentially, plans are prohibited from disclosing RHI for purposes of conducting a criminal, civil, or administrative investigation into any person for the act of seeking, obtaining, providing, or facilitating legally rendered reproductive health care. And also legally rendered is defined broadly, and it's if it was legally rendered in the state in which it was provided. So in this instance, if Texas is trying to seek records from someone who went to California who received legal reproductive health care, because that was legal in California, it's protected as RHI. If someone is requesting RHI so if there's 4 categories where if someone's requesting RHI, plan sponsors need to require an attestation. So those are health oversight activities, federal or administrative proceedings, law enforcement purposes, or coroners or medical examiners. If any of those 4 categories or 4 groups are requesting RHI about a plan participant, you need an attestation that from them that the reason that they are requesting it is not prohibited under this final rule. So in terms of the effective date, everything is effective December 31st of 2024. The notice of privacy practice update is technically not required until February 16th of 2026. But I would recommend probably updating it in advance of that with, again, an asterisk. So next steps, plan sponsors should create your attestation. There is a model that was recently issued by HHS. I would suggest using that model, modifying it obviously for your group health plan name and those types of things, but just use the model, have it ready to go. Update your HIPAA documentation, including your policies and your privacy policies and procedures, your notice of privacy practices, and your business associate agreements. The final rule does apply to business associates, so business associates cannot use this information in a way that the plan sponsor couldn't as well. The Notice of Privacy Practices, that is a document that's distributed to participants. It's required to be distributed every 3 years. Most plan sponsors distribute it every year just so that they can stay, they don't have to track and calendar that 3-year deadline. So I was telling plan sponsors to just update it now. However, my asterisk about updating all of this documentation is that depending on the results of this litigation, these rules might be stayed before the effective date. So we're kind of in a limbo right now. Is the effective date going to come first, or are the regulations going to be stayed? And then if the regulations do become effective, depending on the outcome of the election, will this entire final rule be scraped? There are a lot of questions in terms of enforcement and how this is going to ultimately pan out. But it's certainly something to start thinking about now, especially given the potential December 23rd deadline. And I think this is another really good reminder to conduct your HIPAA compliance training. Best practice is to do that annually. But even if you haven't been doing it annually, in light of these new final rule, you're going to want to do it to make sure that the individuals who might be receiving potential requests for RHI really understand when they can disclose it and the need for an attestation. So I think those are both really important things to supplement in terms of your normal HIPAA training. So fiduciary obligations, I talked about this in the forfeiture context. And candidly, that is typically where we would talk about fiduciary obligations on the qualified plan side of things. Because while ERISA imposes fiduciary requirements on both welfare plans and qualified retirement plans, with qualified retirement plans, I think there was just so much more of a focus because you would have a trust and you have assets and you have employee dollars and you were responsible for them. For health and welfare, typically you're paying those benefits out of employer assets. You might have fully insured programs. So there just wasn't as much of a focus. But that's not to say that's correct, because again, ERISA imposes these fiduciary obligations on all ERISA governed plans. So I think it's important when we talk about it to understand, specifically, I want to talk about it in the welfare plan context, because there's been some interesting litigation in that space. But again, taking a step back, when we think about it, what is a fiduciary? So ERISA defines it as any individual or entity that exercises authority or control over employer-sponsored benefit plan or the management of that plan. So for 401k plans and for welfare plans, that's going to be the plan sponsor, plan administrators, third-party administrators, which are obviously common. And then there are implied plan fiduciaries. And those are individuals who might not be named in the plan documents, might not even know that they are fiduciaries, but because they are exercising that discretion and control, they are considered fiduciaries under ERISA. The key point, okay, so I'm a fiduciary, or, plan sponsor, I'm a fiduciary. What does that mean? So the fiduciary must act in the best interest of plan members. Now, that doesn't mean that you need to be 100% perfect, or, in the 401k context, that you need to, completely protect your participants from all losses, nothing like that. But you're held to a very high standard, and you need to act prudently and reasonably and in the best interest of plan participants. And I think the biggest thing for plan sponsors, and what the issue has become specifically in this welfare litigation, is that plan sponsors, if I don't understand my plan design or my plan terms or what my PBM agreement says, which I completely get, I read PBM agreements and I'm like, what is this? And most, plan sponsors have other jobs. They have their actual company that they're trying to run. But how can you be acting in the best interest of the participants if you don't understand the plan? And I think that's really the impetus for a lot of this litigation right now. So the liability is, if I'm an ERISA fiduciary, the plan is liable, but also there can be personal liability, because again, you are held to that standard. And I think another reason for the focus on this now is that the Consolidated Appropriations Act of 2021 required service providers and PBMs and a bunch of different vendors to provide more information. So now they're saying, like I was saying before, plan participants are saying, well, now you can understand these PBM agreements. You can benchmark and see that we're paying, way too many fees. And that's not in our best interest. So fiduciary, you violated your obligations. And that's the Johnson & Johnson lawsuit that we're going to talk about when we get to litigation. So for a health plan, what can we do to help mitigate our risks? And I say mitigate your risks because I tell my clients this all the time, and I'm sure you guys acutely understand this as in-house counsel. Nothing is going to prevent anyone from bringing a lawsuit. Even if you follow, absolutely every best practice, there's no kind of safe harbor when it comes to these things. A plan participant can still make a claim and allege a violation. However, obviously, the more best practices you're following, the more documentation, the more that you're showing you're taking the reasonable steps to fulfill your fiduciary obligations, the better you're going to fare in court. So obviously we want to do right by the plan and the plan participants, but we also want to, have a good file for if a plan participant sues us. So in terms of fiduciary best practices, documentation review. Again, if you're a fiduciary, understanding what your plan documents say, being able to answer questions about them. I can't tell you how often the DOL will come in and do an audit of a plan and want to speak to, the Total Rewards Department and will ask them questions like, well, are you self-funded? Or are you fully insured? And, Total Rewards doesn't know. And the DOL says, how can you not know this? So understanding the basics of the plan document. Vendor due diligence and cost benchmarking. Again, understanding what we're paying our vendors, regularly conducting RFPs, and making sure that the costs are reasonable. Again, you don't have to go with the cheapest option. You can say, we went with, Anthem over this vendor because they have better network access or XYZ, but knowing why you're making those decisions and regularly reviewing those decisions. Data collection and risk management, obviously, proactively and identifying potential risks, compliance adherence and conflict of interest avoidance. Again, potentially considering bringing in a third party to make sure that your plans are compliant with all laws. And when you're making fiduciary decisions, bringing in a third party to say, yeah, there's no conflict of interest here, or obviously, again, as an employer, you're always kind of wearing those dual hats of settlor and fiduciary, having someone to come and check and say, yeah, this is reasonable, even in light of kind of this inherent conflict. Education and training, provide regular resources and training sessions, both to executive decision makers, frontline benefits administrators. Again, we want people to understand the decisions they're making and why they're making them. Transparent communications to employees, I think that is crucial. Third-party reviews. Again, it can be pricey, but having an independent third party come in and check the plan's compliance with legal requirements, fiduciary standards, identifying areas of improvement. Again, that serves as a check for plan sponsors, but I think it's also a benefit that you are on the right path and you're showing that you are really proactively engaged and concerned. Documentation and record keeping, I think this is one of the biggest things that I really emphasize to clients is that you can have a board meeting or a committee meeting and have a really, really robust conversation to select between 3 PBM managers. I mean, quite frankly, that is typically what happens. There's a lot of discussion, there's a lot of debate, and you ultimately reach a decision. But then it's memorialized as we picked, a firm RX. Done. Well, that's not showing the fiduciary process. That's not showing the conversations that were had and the debates and why we're having those discussions and the presentation materials. So, really documenting the decision-making process, the factors considered, and why a decision was ultimately reached really helps bolster the argument that I, as a fiduciary, understood and was engaged in active decision-making. And proactive cost containment, that's the focus of this PBM fiduciary litigation, and that's going to continue to be the focus because I understand from employer perspective, a lot of conversations I'm having with clients are the astronomical expenses to employers for providing health benefits, and I get that. But it is also very expensive for employees. I'm sure you guys understand that as individuals. So making sure that as a plan sponsor, when we're thinking about cost containment, we're thinking about it as both a plan fiduciary and how is this impacting our participants, and thinking about it as an employer, how is this impacting company costs? All right. So the MAPIA rules, again, this is the latest and greatest. The final rules were published on Monday. So I'm going to try to walk through them, but obviously we're going to talk to your advisors about this now that the final rules are out. I will say the final rules did push back some implementation for some of the more significant provisions, which is great, and it lessened the fiduciary standard that a lot of employers were concerned about, which is also great. But essentially, the Mental Health Parity and Addiction Equity Act, it's the general idea that mental health and substance use disorder services need to be provided in parity to medical surgical services. And there is, it is very complicated, the analyses and the comparisons, but a particular focus of late has been non-quantitative treatment limitation. So the quantitative treatment limitation is something that is easily quantifiable, hence the name. So if I'm spending a $30 deposit to see, or a $30 copay, to see an optometrist, but I'm spending $100 to see a psychiatrist, you can understand that that is not in parity, that quantifiable limitation. However, you have things like non-quantifiable treatment limitations, and those are prior authorizations, formulary design, failed first procedures, denying a treatment because it's experimental or investigative. All of those you can't quantify, but they have very significant impacts on mental health and substance use disorder services. So as a result, there has been a large focus on NQTLs, those non-quantitative treatment limitations, as it relates to mental health and substance use disorder. So the Consolidated Appropriations Act of 2021, required that all group health plans conduct a non-quantitative treatment analyses. And this analyses would be the DOL could come in and ask for it at any time. You had 20 days to provide it. And then they were required to issue a report to Congress kind of outlining the findings as a result of those analyses. I will say thus far, the reports to Congress have been not great. I don't think there's been a single plan in compliance right from the beginning. So there has been a lot of back and forth with the agencies, discussion. And, candidly and practically speaking, from an employer perspective, these are really difficult to do. You are relying on your third-party administrator. You're not, behind the scenes doing the prior authorizations for mental health treatments. So you don't know what criteria you're using. But you, as the employer, have the obligation to make sure that you have this analyses and that you're able to provide it. So it's very difficult because you don't have the information, but you're ultimately responsible for the output. So in addition to that reporting requirement, the tri-agencies published a rule back in August of last year, which was finalized on Monday. Again, kind of addressing these non-quantitative treatment limitations and also addressing what is required in those analyses. So, when I say provisions to watch in the final rule, I guess I am talking about what is in the final rule. uh, but going back to the analyses, one thing that I do want to emphasize is that the final regs did codify and make it statutorily clear that those are required. And they emphasized again that plan sponsors should not wait until they receive a request. And now they actually shortened the response time to 10 days. And again, emphasizing this needs to be done. You need to be on top of this now and not just wait until the agencies request your analyses. So, again, I know this is a very difficult undertaking for plan sponsors. Hopefully, you've already engaged vendors and worked with your TPAs and have something done, at least a draft. Again, it's going to need to be updated in light of these final rules, but at least having something started. So, one of the things, again, we're talking about NQTLs. One of the things that was in the proposed rule was implying this mathematical test that we currently use for quantitative treatment limitations to NQTLs, which was going to be very difficult. But the final rules say we do not need a mathematical test. However, we are reinforcing the idea that plans cannot impose NQTLs that are more restrictive than the predominant NQTL that applies to substantially all medical surgical benefits within the same classification. Again, this is technical. I guess from a good perspective, we don't have to use the strict math standard, but again, we need to make sure that NQTLs, we're using the substantially all and predominant threshold. In terms of access to services for autism treatment, this was something that was, I guess, somewhat ambiguous under MAPIA. It is and was the topic of a lot of litigation, but the final rules did clarify that intellectual and developmental disabilities, including autism spectrum disorders, are defined as mental health conditions and protected by MAPIA. So that is codified in the final rules. In something else that I think will impact potential restrictions, because we do have a lot of prior auths surrounding autism treatments, potentially limitations, but there's also a lot of new experimental investigative treatments, and a lot of plans will design certain treatments for that reason. But there is now a design and application requirement in the final rule. And basically, this says that for NQTLs, you can't use discriminatory information, evidence, sources, or standards that systematically disfavor or are specifically designed to disfavor access to mental health and substance use disorder benefits when designing those NQTLs. So I think that's really where, the DLL is going to have questions, is if I'm excluding a treatment for autism services because as a plan, I think it's experimental or non-proven. Where am I getting that evidence? And can I show that that evidence isn't discriminatory against providing mental health and substance use disorder services? Again, this is extremely, extremely technical, and you're going to need your vendors to help you with this. Their willingness to cooperate, might be another issue. Additionally, I'll go back to this other slide because it also relates to autism treatment. One of the final rules requires this meaningful benefit standard, which means if I am providing treatment for a specific service, I need to provide meaningful benefits in every classification. So under MAPIA, there's 6 different classifications. So I think that the design and application requirements and the meaningful benefit standard are really, really going to limit plans' abilities to carve out a lot of these mental health and substance use disorder treatments. For example, meaningful benefits for substance use disorders, let's say I cover inpatient treatment, that's a meaningful benefit in that classification, but I'm not covering a lot of drugs to treat substance use disorders. Well, then I'm not probably providing meaningful benefits, and the pharmacy classification. So you can see how both of these are going to have a significant impact on the requirements for plans to provide coverage for mental health and substance use disorders, which I guess was the entire impetus behind the final rule. But for plan sponsors, this is complicated. Fiduciary liability, this was the item that I said the final rules relaxed on a little bit. Thankfully, initially they were proposing that the final that a plan fiduciary had to be named and certified that NQTL analysis was complete and accurate, and they found it to comply with the applicable contents requirement. That was very concerning because, again, as a plan sponsor, these analyses are so complicated and so dependent on information that is completely outside of your control. To have to certify to a fiduciary standard that you understand the analysis and that it complies with all legal requirements was just daunting. The final rule did lessen that. Now a certification is still required to be made by a fiduciary on those analyses, but they can certify that they've engaged a prudent process to select one or more qualified service providers to perform and document the NQTL analysis. So that is much more preferable. You can say, like your normal ERISA fiduciary standard, I engaged in a process, I selected a reasonable vendor, they were responsible for this analysis. So that was a welcome and proposed change. That brings us, thankfully, to a break. Well, not a break, but a time for you to put in your code word that you are still awake after all the NPIA slides. As mentioned at the beginning of the webinar, we need to take a brief moment to satisfy CLE requirements by delivering the following code word. All Kansas, New York, New Jersey, and Pennsylvania licensed attendees must type the code word rules into the Q&A section of the screen. Please make sure to hit the send button so that it registers. In case you missed it the first time, the code word is rules. Give everyone a minute there. Great. We're almost done with MPIA, I promise. So something else to, again, watch in the final rule is this idea about data collection and evaluation. The final rule did give some more leeway in terms of how and what data is collected, but essentially, the departments are very concerned about a common complaint that you might have experienced or heard your plan participants experience, and that's in terms of network composition for medical or for mental health and substance use disorder providers. They'll say, okay, well, there's 1,000 primary care providers in my network, and there's 2 therapists, and it's really hard to find coverage in network. So again, they're going to require plans to start collecting data and quantifying the impact of NQTLs as it relates to provider network, paying out of network providers, making sure that, they're really focusing on network composition. There's going to be a lot of data points that you're going to need to include in the analyses, but I would say overall, they're really focused on network. And also, if you find a huge discrepancy when you're collecting and evaluating this information about NQTLs, plan sponsors are going to have to take reasonable action to address those NQTLs. Again, reasonable action, there's no prescribed requirement, but if you're submitting your NQTL analyses to the DOL and you're saying, yeah, there's not a single substance use treatment provider within a 50-mile radius of 90% of our population, that DOL is going to say, okay, well, what are you doing about that? I mean, now you have the information, about it. What are you doing about it? And again, this idea of information, the more information as a plan sponsor you have, the more it influences your fiduciary obligation to say, am I fulfilling my fiduciary obligations now that I understand that there's this huge discrepancy in terms of network composition? In terms of effective dates of the final rule, technically it is still effective 1/1/2025, but those big provisions that I talked about, the design and application requirements, the meaningful benefit standard, which again, that's going to probably be significant to make sure that you're providing meaningful benefits, needs classification, and that data collection, that is all effective 1/1/26, and the requirements of each of those that are to be required in the NQTL analysis also are not effective. It's 1/1/26. So you need the analysis now, and parts of this, the certification, are going to be effective 1/1/2025. But there are still some components that will be effective 1/1 next year, but definitely things that we want to start thinking about now to the extent you haven't already. I mean, a lot of my clients regularly have conversations about MAPIA and plan design in response to litigation, but obviously those conversations need to become a little bit more substantive now that we have the final rules. So what to do now? I was kind of just talking about this, but await the final rule. Well, we did. It came out on Monday. Ensure compliant comparative analysis. Again, I cannot emphasize this enough. I know it is extremely difficult to do, but to the extent you haven't done it already, I think these final rules really make the obligation very concrete. It was before, but now they're very serious about it. So, talk with your counsel, start engaging, make sure you have it, and make sure you're regularly reviewing and updating it, especially in light of the requirements effective 1/1 next year. Review your service provider agreements. Make sure that it is very clear who has the requirements to complete the analysis. If you're giving it to a third-party provider, make sure that they are expressly acknowledging that. And to the extent that they're not, make sure that your service provider agreements allow you to have access to the information that you're going to need to complete the NQTL or whoever's going to complete it analysis. Make sure they can get that information. Develop a work plan to update MAPIA compliance. Again, I think you can see by how many talking points there are. These final rules and all MAPIA rules are extremely complicated. But starting now to identify, okay, this team's responsible for the comparative analysis. This team's responsible for the data collection and reviewing that and making reasonably addressing any discrepancies. This team's going to be responsible for reviewing our current plan design and those types of things. If you don't have a team, starting a team now. And identifying a named fiduciary, I think this was going to be a lot more crucial when we needed the fiduciary to be responsible for the attestation on the analysis. There still is going to need to be someone who does that. So, making sure that as part of that workforce plan, you understand who is going to be responsible for selecting a vendor, assuming you're not going to do this yourself, which I cannot imagine wanting to do this yourself. But, making sure that you have someone who understands their fiduciary obligation to select that vendor who's going to do that analysis. Okay, cybersecurity. Again, this is something that, I think we've been talking about, ironically, again, in terms of updates since I finalized these slides. The last update we heard from the agencies about cybersecurity was issued by the DOL in 2021. I'm sure most of you guys are pretty familiar with it. Nothing was that groundbreaking. But the DOL really wanted to emphasize, this is, things we need to be thinking about. It's the baseline. You should be doing more than this, but retirement plan sponsors be thinking about these things. And it was 3-part guidance, best practices for plan sponsors, a tip sheet for participants, and then there was another component of guidance. You can easily find it on the DOL's website. On Friday, though, the DOL issued Compliance Assistant Release 2024-01. And all it did was confirm that the agency's 2021 guidance applies generally to all ERISA-covered employee benefit plans, including health and welfare plans, which makes sense. I think this was the reverse of the fiduciary focus. I think health and welfare, we've always had more of a focus on cybersecurity because of HIPAA and those obligations. So the DOL wanted to remind retirement plan providers, no, you also have an obligation to protect participant data. Now they're coming back and saying, listen, the stuff we put out in 2021, that applies to all ERISA governed plans. Best practices, follow that. And again, that's the baseline. That's not to say you shouldn't be doing more. But again, if you're not checking these boxes at minimum, we really, you need to start having those conversations. So these were the best practices, I think, that are comprehensive on the slide deck. But in light of the EPSA guidance that came out on Friday, I want to kind of emphasize what they say are the best practices. Because again, the DOL just on Friday revisited this guidance and said, you need to use these, all plan sponsors. So they list maintain a formal, well-documented cybersecurity program, conduct prudent annual risk assessments, implement a reliable third-party audit security control annually, follow strong access controls, ensure that assets or data and stored in cloud or managed by a third-party service provider are subject to appropriate security reviews and independent security assessments, have effective business resiliency programs, and encrypt sensitive data. So all of that is really covered by, again, this more comprehensive list. I will say third-party audits, there is a dual meaning. One meaning make sure you're auditing your third-party service providers, and then consider bringing in a third party to audit your own technical controls. Additionally, one thing that the DOL did not address, but I think is important to address, is cybersecurity insurance. Hopefully that's something that you guys all have as plan sponsors, but given the recent data breaches and the Move It data breach, the Change healthcare data breach, you can see how these are impacting plan sponsors and plan participants. So making sure that you have appropriate cybersecurity insurance is important. And in terms of cybersecurity, and I guess all things World Wide Web, we also have artificial intelligence. I think like most things, there are a lot of good that comes from artificial intelligence in the benefit space, but there are also some potential negatives. The good when we think about benefits, and these are just some things that I thought about the top of my mind, is generating user-friendly documents for participants. Summary plan description, certain notices are intended to be drafted very employee-friendly and user-friendly, and we frequently get complaints that they are not. As attorneys, I'm sure you could appreciate that that's probably because I or your counsel is drafting a lot of those documents, and sometimes lawyers don't make things as user-friendly as possible. So AI can certainly help. That's kind of one of the main jobs of AI, is to take a lot of complicated information and distill it down to user-friendly material. Approving and denying benefit claims more accurately, detecting fraud, helping employee decision-making. I think this one is also something that is really invaluable. I can't tell you how many times I've had to explain to my own sister the difference between an HSA and a health FSA every open enrollment season. And I think that's something that, plan participants are frequently saying, I don't understand what a high deductible health plan is. I don't understand what a PPO is. I could definitely see the benefit of having AI and being able to use some sort of AI program and say, hey, I'm a healthy 20-year-old. What health plan should I look at? Or I have 10 kids. What health plan should I look at? Should I have an HSA or an FSA? What are the advantages? What are the disadvantages? Helping walk employees through that decision making, because I'm sure, if you work in an HR department, I'm sure you get to field all those questions about, well, do I need a dependent care FSA? What expenses are, can I charge to that? So definitely an advantage there. And that goes to addressing employee questions. But with all of the good, there's obviously potential problems that, plan sponsors need to consider. Again, as a fiduciary, we want to make sure that we are acting reasonably and considering both the advantages and the risks of potential services, in this case being AI. Obviously, federal, state, and privacy laws. I think most large-scale AI designed for benefit plans is in compliance with HIPAA and state privacy laws, but obviously making sure that you're really vetting your service providers who are using AI, and acknowledging that you might be feeding AI really sensitive information and ensuring that all the appropriate technical safeguards are in place if you're going to use AI. Fiduciary liability, I think this is going to come up a lot in terms of, I'm sure for those of you who are familiar with AI, AI has propensity, I forget what the exact term is, but to say something that is completely false, but obviously it gives this air of authority. So I could see this coming up in terms of if I'm a plan participant and I say, hey, is this drug covered under my plan? And AI says yes. And then I go purchase the drug, it's not covered. I have a significant out-of-pocket expense. I come back to the plan and I say, hey, your AI chatbot told me this was covered. Making sure that information, to the extent you can, output by the AI is correct and accurate, as part of the fiduciary obligations. And potential discriminatory and harmful responses to participants. The other disadvantage universally of AI is that it has been known to have a propensity to discriminate based on the way that it is programmed. So making sure that if you have AI assisting you in making claims and benefits decisions, making sure that it is not generating outputs that are biased towards certain participants and those types of things. So it really is a catch-22. We're using AI to kind of remove some of the human fallacy, but then you also kind of need a human check in terms of the information it's providing and the decisions it's making to make sure that the AI isn't succumbing to its own fault. So I definitely think this will be an ever-evolving space in benefits, and probably conversations that you're already having with your service providers and counsel. That brings us to our litigation update. And I'll go through this fairly quickly because, I think we touched on a lot of this before more substantively. In terms of 401k plans, ESG litigation, for those of you not familiar, ESGs are environmental, social, and governance funds. The DOL has gone back and forth as to whether or not 401k fiduciaries can consider ESG funds in their 401k plan lineups based on the administration, whether or not it's permissible. And I guess, companies are trying to be more socially conscious and make socially conscious investment decisions and participants are asking for more socially conscious investment decisions. The DOL's current position is that you can consider them so long as it is used as a tiebreaker. However, a group of states have sued the DOL to enjoin the application of the rule. A district court in Texas actually dismissed that case in 2023, but it is currently pending before the U.S. Court of Appeals and the Fifth Circuit. And again, this has truly been administration by administration, DOL specific. So if the Fifth Circuit doesn't decide before then, depending on the election, this could also change. Mortality table litigation. This was a big topic of litigation a few years ago, still ongoing. And I guess that's the point of including it on this slide. Five additional lawsuits have been filed in 2024, again, maintaining the use of any mortality tables aside from the current mortality table is a violation of ERISA. The DOL actually petitioned the U.S. Court of Appeals to reopen its class action lawsuit against IBM that was dismissed in 2022, which is interesting because I think the DOL, although they haven't said what mortality tables they need to be using, the fact that they're trying to insert themselves in this litigation is telling. So I think we'll see more on that, especially with the mortality table litigation that was instituted this year. Section 1557, this is the provision of the ACA that prohibits discrimination on the basis of race, color, national origin, age, disability, sex, to help programs and activities receiving federal financial assistance. The final rules that were codified also expanded that protection to clarify that on the basis of gender included LGBTQ plus services. That is currently under a nationwide preliminary injunction. However, that is not stopping individuals from bringing suit under Section 1557 and as its own individual claim of relief. So we do see a lot of participants bringing suit under 1557 for a variety of reasons. one of which being family planning benefits. This has come up a few times, but the problem here is that in both of these cases, you have LGBTQ plus individuals challenging the medical necessity criteria used by group health plans and insurers to determine participant eligibility for infertility treatment, saying that that violates Section 1557. The problem is that the criteria for infertility is that is used by most plans, which is you're considered infertile and eligible for reproductive assistance under the medical plan if you haven't been able to conceive after a year of unprotected intercourse or failing to conceive after 12 cycles of donor insemination. And these LGBTQ plus individuals are arguing that this standard is unfairly prejudiced because they can only satisfy the second prong and they need to expend their own dollars out of pocket to satisfy that, to show that they're infertile, or heterosexual couples could satisfy either prong. Problem is that, so plan sponsors, I've had plan sponsors say to me, well, let's just eliminate infertility and say, we'll give anyone reproductive assistance treatment who wants it. If you want to have a IVF cycle, go have one. Well, then you run into problems with the Internal Revenue Code, because if you don't have a diagnosis of infertility, receipt of those treatments does not constitute medical care under IRS Code Section 213D, which is going to have potential taxation issues, because if you're trading services provided using pre-tax dollars and they're not medical care, that's the problem. So it puts plan sponsors in a very precarious situation of, how do I balance the interest of my LGBTQ plus employees, their claims and appeals, the potential litigation, and how that might impact my company publicly, versus concerns about the IRS and tax issues. And I can't say that I have a good issue. I can say that this is something that I personally am very invested in. I've brought this to the IRS at numerous conferences, and they just joke and say, we're behind the times, shocking. I wrote an article about this. It was the cover story of Benefits Magazine last fall. I think this is something that employers, they're in a really difficult spot, and they want to do what's right for their employees. And it's just it's a real catch-22. So that's something that, again, is also being litigated under Section 1557. Autism therapy limits. Again, like I was saying, the final rules make it clear that autism therapy is required to be treated as a mental health condition. This case, the Seventh Circuit actually affirmed the lower court's ruling in favor of the insurer who denied the claims, because they used, at the time the claims were sent in, they were using then relevant medical data, which has subsequently been disproven. And they changed their plan design, but the participant argued it should have been applied retroactively. And they said, if you used reasonable evidence at the time, that's acceptable. But again, I think it goes back to the final rule and making sure that the evidence you are using is reasonable, reputable, and not discriminatory in any way. The fiduciary litigation is what I was alluding to before. In terms of welfare plans, you have the Johnson & Johnson case and the Navarro case, both of which have very similar premises. And again, we're already seeing plaintiffs' firms solicit participants for additional class actions against large employers. Basically, they're saying the PBMs paid too high prices for generic drugs that were available at significantly lower prices, and those increased costs are then passed on to, were paid by plan assets. Participants were required to pay a higher amount of out-of-pocket costs because they failed to act as a prudent fiduciary, and they paid too much in administrative fees. So again, this is an excessive fee suit with some additional intricacies on the welfare side of things. So again, that goes back to our earlier conversation about making sure that we're being prudent fiduciaries, both on the qualified plan side and the welfare plan side. And in light of this litigation, the Johnson & Johnson litigation, really making sure, particularly with PBMs, because those are notoriously convoluted and complex, understanding how we're paying for things and what we're paying for as plan sponsors. So I I have to end it with Chevron, but as I said, Kate did a really good job of explaining kind of how we got here and what the potential implications will be. I think post Chevron, from a benefits perspective, obviously, there's going to be a lot of instances where we have the DOL and IRS and we give them deference, and, what kind of deference will we be affording post Chevron. I will note that Chevron does not impact two things in the benefit space. Agency IRS opinion letters, private letter rulings, and revenue rulings were never entitled to deference, so there's no change in the standard there. And Congress can expressly delegate determination to an administrative body. And so that will be respected and unchanged. For example, the affiliated service group rules, Congress put out the statute and then just said, unless otherwise determined by the IRS. And so those determinations by the IRS will receive deference. However, these are, again, hot topic issues that I don't know if the impact of the current litigation might be determined based on the level of deference. The DOL's ESG rules, obviously, that's before the Fifth Circuit. If the Fifth Circuit doesn't have to give deference to the DOL, that might have a reverse outcome. Section 1557, again, the final rule is currently under a preliminary injunction, but if we don't have to give deference to HHS, that might have a different outcome. Forfeitures, we talked about that a lot. I think with that, again, the IRS has always held the position that you can use forfeitures to offset employer contributions. If we don't have to give deference to the IRS, and we really wouldn't have to anyway, because this is a DOL fiduciary issue, but now that, the courts might not have to consider the IRS's longstanding position, that might impact that litigation. The DOL final fiduciary rule, that is also currently under an injunction, and that does impact whether or not someone's a fiduciary in terms of providing investment advice to plan sponsors. That is going to potentially have an impact. And then the RMDs, the relief that I was talking about before, that can, we've had relief up until January 1st of 2025. But if someone were to sue and challenge that relief, the IRS might not get the deference that they're looking for. And that's going to cause more confusion in terms of RMD distributions and those applications. So that was a lot, and I took extra time, but I'm always happy to talk about benefits. So I think that's where we're at. I'll see if I have not been seeing the questions, but if anyone has any right now and would like to jump in.
Okay.
All right. Well, seeing none, Kate's here as well. If anyone wants to pop in the chat and ask a question. But if not, I'll start reading the closing remarks. Thank you again for participating in today's CLE webinar. In approximately 30 business days, you'll receive an email link with a link to your CLE certificate. Your webinar login details will be used to process these certificates. No additional steps are required. As a reminder, the code word requirement is only if you are seeking credit in Kansas, New York, New Jersey, or Pennsylvania. Have a great day, and thank you so much for attending.